Of these notes is to compare the state courts with the federal court system. Now, if you're looking at the PowerPoint slide right here, you'll see that I have the three levels of the California courts. You have the California Supreme Court, the California Appellate Courts, and the California Superior Courts. The Superior Courts are the main trial courts. If you get arrested for burglary, robbery, rape, murder, whatever you might be arrested for, you would have to go to trial at a California Superior Court because you committed a state crime. Now, if you commit a federal crime, you would start your trial status at the U.S. District Court level, which is over on the federal court side. Now, that's if you commit a federal crime. A federal crime could be something like robbing a bank, stealing someone's mail out of their postal box, because that's a federal crime, or killing a federal official. Any of these types of actions would be considered a violation of federal law. So you would go to a U.S. District Court. We actually have a U.S. District Court in Santa Ana. It's right next to the Santa Ana Superior Court for California. So it's interesting. You have a state Superior Court, California Superior Court, and a U.S. District Court that are both in Santa Ana. The U.S. District Court in Santa Ana is located in what is called the Ronald Reagan Building. So you have two different court systems. You have state court systems and you have a overlapping federal court system. So as you can see, you have California's three levels and you have the federal court's three levels. Now, all 50 states have their own state court system. Overlapping the state court system is a federal court system. Now, most crimes that are committed are typically state crimes. So if you commit a state crime, you're going to go to a state court. However, as I said previously, if you committed a federal crime, you will go to a federal court. Every state has at least one federal district court located in it. And there are also 12 regional U.S. Courts of Appeals, and of course only one U.S. Supreme Court, which exists in Washington, D.C. So by telling you this helps you understand that we have what's called a dual court system. You have 50 state courts that are overlapped by a federal court system. If you look at what we have here, I have three rectangles for the California state courts and three rectangles for the federal courts. So I want to give you two different stories to help you understand the relationship between state courts and the federal courts. So the first issue we're going to address is a crime that's committed in a public school. Now, if a crime is committed in a public school, that's going to be considered a state crime. So here's my issue, as you can see listed below. Let's say John Smith was arrested by school officials in which they conducted a strip search and found that he had a jewel in his underwear, which would be in violation of school rules. Reasonable suspicion was based on the fact that John, being identified by other students for selling jewel vaporizers of different flavors at school, was a known trader of jewel products, which were against school rules. Now, if you remember what reasonable suspicion is in comparison to probable cause, in public schools, your school officials have a responsibility to maintain a positive learning environment. So that would mean they are empowered to try to eradicate any type of drug use or drug trade that is taking place in a public school. Clearly, it is not cool for John Smith to sell a jewel in a public school, and that's also in violation of a school rule. What's interesting about this case is how they found that jewel by conducting a strip search. They actually had him stripped down to where they found that he had a jewel located in his underwear. Now, let me just say this one thing. This is a hypothetical story, but it could happen. So, let's say John Smith is arrested. He then is going to go to a superior court, a California Superior Court, which we have a court over in Santa Ana. And there he would be tried for possession with the intent to sell at a public school. Well, the trial would take place. where you would have a jury would be impaneled, the evidence would be introduced, witnesses that testified about John being known as a jewel trader at the public school would testify against him. And at the end of the trial, the jury would have to determine if he's guilty or not guilty. Well, let's just suggest the jury ruled after the trial was conducted. The jury ruled that he was guilty. So he then is sentenced. However, his lawyer is going to appeal because his lawyer is going to argue it was not a reasonable search when they did a strip search to find a jewel in John's underwear. Okay, now, where would you appeal if you were John's lawyer? You would appeal at an appellate court located also in California in Santa Ana. There are actually 6 appellate courts throughout the state of California. We happen to be in the 4th appellate district. So in Santa Ana, they have the 4th California Appellate Court of the 4th District. It's located in Santa Ana. And this is where John's lawyer would appeal. Now, when you appeal at an appellate court, you're not going to retry the case. See, an appellate court only has appellate jurisdiction. What does that mean? That means they can only review and revise what took place in a lower court. Well, the lower court was the California Superior Court. So what are they going to be looking at when they review this case? Well, here you only have a panel of 3 judges who will review and revise what took place at the original trial. Now, the question that John Smith's lawyer is arguing is the evidence that was introduced, the jewel, should not be used at trial. And what John's lawyer is arguing is that the exclusionary rule should have been applied and the jewel should not have been admitted as evidence because it was obtained unreasonably in violation of the 4th Amendment's unreasonable search and seizure. Well, the panel of 3 judges will listen to the lawyers. You're going to have the lawyer for John Smith, and you're going to have the district attorney representing the attorney that prosecuted the case, representing the prosecutor, who's going to try to argue that the evidence should be admitted. So all you have is 2 lawyers. You're not going to have witnesses. You're not going to have a jury. And you have a panel of 3 judges that will listen to their arguments. Well, after they deliver their arguments, the panel of 3 judges will give its decision. And let's just suggest they decided the conviction is upheld. Well, now what is John Smith's lawyer going to do? Well, he can appeal. Where would he appeal to? Well, that's what's next. He would appeal to the California Supreme Court. The case has arrived to the California Supreme Court. Now, here's an interesting fact about the California Supreme Court. It actually travels to 3 different locations. They start for 4 months in San Francisco, then they'll hear cases in Los Angeles, and then finally the last 3 months they'll finish hearing cases in Sacramento. Well, let's say John Smith's lawyer decides to appeal the conviction that was upheld by the California Appellate Court. So he appeals it to the California Supreme Court. Now, when it goes to the California Supreme Court, they have 7 justices. The 7 justices will be the ones that will hear the case. And again, just like at the appellate court, the 7 justices will only hear the lawyers make their arguments. Now, the lawyers had previously provided legal briefs to the court so they could read them over, and then the justices will ask the lawyers questions while they present their case as to why they believe the conviction should be overturned or whether or not the conviction should be upheld. Well, John Smith's lawyer will make the same argument. The evidence that was allowed at trial, the jewel, should have been excluded, and therefore a new trial should take place without the jewel being used as evidence. Well, again, since the California Supreme Court is using appellate jurisdiction, there's no witnesses, there is no jury, it's just the 7 justices. Well, this is the court that will have the last opportunity in California to hear this appeal. Let's just suggest the California Supreme Court decides to uphold his conviction. Well, now what is John Smith's lawyer going to do? Well, he now can appeal to the Supreme Court. Now, he doesn't go to a lower federal court. He has to go right to the U.S. Supreme Court, and he can request that they take up his case. He can request that they issue a writ of certiorari so that his case will be heard. And something called the Rule of Four, if 4 justices agreed to hear his case, then a writ of certiorari will be sent requesting that this case be brought up to the Supreme Court. Now, the case has been adopted or accepted by the U.S. Supreme Court. 4 justices agreed to hear the case. A writ of certiorari was issued, and now the Supreme Court will hear the case. Now, you might even get the ACLU decide to also join in on this case. American Civil Liberties Union might want to also write what's called an amicus curiae brief, also known as friend of the court brief. Now, the ACLU is not a party, not a litigant in this lawsuit, but they might have an interest in this case now being called Smith versus California. Now, what would the ACLU might argue? They might argue, along with John Smith's lawyer, that it was an unreasonable search when they conducted a strip search of a high school student in search of a jewel. So, let's say this case is now being presented before the Supreme Court. The ACLU could have their attorney make arguments before the Supreme Court after filing an amicus curiae brief. John Smith's lawyer could make an argument 30 minutes to 45 minutes before the Supreme Court after he had already written a legal brief making his case known to the Supreme Court. And of course, the state of California will send its attorney to the U.S. Supreme Court to also argue that they think the conviction should be upheld. Well, let's say that the lawyers make their arguments before the Supreme Court. Supreme Court makes its decision, which only requires a simple majority vote. And let's say the Supreme Court agrees that this case should be retried because the evidence that was used, the jewel, should not be allowed at trial, because they were going to argue that a strip search of a high school student looking for a jewel, in search of a jewel, is not a serious enough substance to justify a strip search. Now, the Supreme Court might argue, well, if you're looking for cocaine or heroin or something that's much more of a serious drug, then a strip search must be justified. However, conducting a strip search is not justified in this case when you're only looking for a jewel. So, the Supreme Court decides we're now going to send this case back down, and when they do so, it's called a remand. So now, the Supreme Court made its decision. It decided to remand this case, which means they're going to send this case back down to its original court, where the trial originally took place. So notice the 2 words here. When the Supreme Court calls a case up, it issues a writ of certiorari. When it sends a case back down, it's called a remand. In this case, the Supreme Court would remand this case back down to the original court, the California Superior Court in Santa Ana, and tell that court they need to retry this case, but this time the jewel cannot be used as evidence. So I would guess that if the trial took place without the jewel being used as evidence, the district attorney would probably argue, you know what, I'm not going to try this case again, case dismissed, which means John Smith would now be released and free to go. Well, that would be a story of a case that originates in a California Superior Court. It could get to the U.S. Supreme Court if the Supreme Court agrees to accept it. One thing I do want you to note, the U.S. Supreme Court has thousands of appeals in which people are requesting that it will call a case up so they can hear their dispute. However, the Supreme Court only hears about 70 to 80 cases a year. So it's highly unlikely that many cases, or your case, someone's case, is going to be heard by the Supreme Court, because a very small percentage of cases are actually accepted and brought up to the Supreme Court. All right, now the next example I'm going to give you is an example of a federal case that will originate in a federal court.